Now, let's talk about protecting concerted activity for a moment. Since the dawn of social media use, employees who have been discharged for what their employers considered to be their inappropriate social media use have brought a myriad of different types of lawsuits against their employers. They claimed discrimination, they claimed breach of contract, they claimed a lot of different things, and most of them lost. And that the courts found, no, the social media use was pretty bad and it was worthy of discharge. But by far, the National Labor Relations Act has been the strongest weapon in employees' arsenals against their employers. Again, whether they are in a unionized environment or not, there's something called Section 7 of the National Labor Relations Act, and that provides your employees with the right to engage in what's called concerted activities for the purpose of mutual aid or protection. They have the right to band together for their collective good, basically. And Section 8 of the National Labor Relations Act prohibits employers from interfering in any way or penalizing employees for their exercise of those Section 7 rights. Now, again, you have to think about what protected concerted activity means. Concerted means in concert, more than one person. So if it's a group of employees communicating, if it's an issue that somebody posts that's a continuation of a discussion in the workplace, it's all very likely to be what's called protected concerted activity. So there's two particular cases that were found in the last year by the National Labor Relations Board, Hispanics United of Buffalo and Betty Page Clothing. In Hispanic United of Buffalo, there was an employee who was critical of the performance of other employees internally within the organization. And then the other employees got mad and went on Facebook and started all attacking the employee who complained about them. The employer was made aware and fired all of those other employees for bullying and harassment. It wasn't harassment in the sense of race, sex, religion. It was just everybody bullying this employee who had the nerve to complain about others' lack of commitment and poor performance. In Betty Page Clothing, employees were discharged for very public Facebook postings criticizing their employer for staying open too late. It's a retail store. They were in a bad neighborhood, and other stores in the neighborhood all closed earlier, and they were concerned for their safety, but they put these things out all very publicly. And in both cases, the board found that the employees were engaging in protected concerted activity and had to be reinstated with back pay. Again, so before you take action against any of your employees for their social media use, think about, is it a continuation of a discussion? Is it about terms and conditions of employment? Is it possibly this protected concerted activity? Now, I want to go over a couple of policies that the National Labor Relations Board has found to be in violation of the National Labor Relations Act. One is Costco. You all know Costco, I think. Employees must be aware that statements posted electronically that damage the company, defame any individual, or damage any person's reputation or violate the policies outlined in the Costco employee agreement may be subject to discipline up to and including termination of employment. Reasonable. A lot of employers have similar policies. And then there was also a prohibition on sharing employee information, including leaves, accommodations, compensation, and contact information. Now, for years, employers have told employees, don't tell anybody how much you're paid. That's confidential. That, per se, is a violation of the National Labor Relations Act. You cannot do that. But again, they put it in writing. This was Costco's policies found in violation of the National Labor Relations Act. Carl Nuts Motors. Courtesy is the responsibility of every employee. Everyone is expected to be courteous, polite, and friendly to our customers, vendors, and suppliers, as well as to their fellow employees. And this is where I think they got into trouble. No one should be disrespectful or use profanity or other language which injures the image or reputation of the dealership. So, again, whenever you use the term image, reputation, damage, that's where the board's probably going to have problems with what you're saying, because employees will think, I can't say anything about the terms and conditions of my employment that's critical, or else I will violate these policies and they'll fire me. So you're chilling their exercise of their Section 7 rights under the National Labor Relations Act. Now, as I said, the NLRB found these policies overbroad. They have a reasonable tendency to inhibit employees' protected activity in protesting or criticizing terms and conditions of employment or employer treatment of employees. And the second bullet is really the most important. If the policy reasonably is read to have a coercive meaning, it will be construed against the employer and therefore illegal. But you do have the right to put certain rules in place if you describe in more detail what's a violation of the policy. So you can't just say, if you disclose our confidential information, you'll be discharged. But if you define confidential information as the formula for Coke, or HIPAA information, or attorney-client privileged information, or the business plans of the company for the next couple of months, those are the things that everyone will realize is confidential information, and you can certainly prohibit that. You can say, thou shalt not be maliciously untrue, harassing, discriminatory. You can still have certain policies in place, but again, when it's a little bit too amorphous, that's when the board is going to have a problem with it.